Hello everyone and welcome to this SCL lecture. Tonight we have with us Her Excellency Tiina Intelmann, who is the President of the Assembly of States Parties to the Rome Statute. And she's going to give us a lecture on the key outcomes of the 12th session of the Assembly of States Parties and the way forward. So my name is Niall Matthews and I work with the Coalition for the ICC, which is a network of over 2,500 NGOs from 150 countries, advocating for a fair, effective and independent ICC and increased access to justice for victims of war crimes, crimes against humanity and genocide. So this lecture series has been organised since 2003 by the Asser Institute, the Grotius Centre of Leiden University and ourselves at the Coalition. So this is our 10th anniversary year. A few details on Ambassador Intelmann. She was elected as ASP President in December 2011. She has a broad range of professional experience in international relations and has previously served as the permanent representative of Estonia to the United Nations as well as to the Organization for Security and Cooperation in Europe. The President previously served as Under-Secretary for Political Affairs and Relations with the Press in the Ministry of Foreign Affairs of Estonia, and she has been working on issues related to the United Nations for over 10 years, most recently successfully co-facilitating negotiations on a system-wide coherence reform establishing UN Women. Ambassador Intelmann has also led negotiations on humanitarian affairs at the UN and holds a Master's of Arts in Italian Language and Literature from Leningrad State University in St. Petersburg. So moving on to tonight's lecture. Last month, civil society from across the world joined states and other stakeholders in The Hague for the 12th annual session of the ASP. As the ICC's oversight and legislative body, the states parties that make up the Assembly discussed and made decisions on a number of issues central to the court's operations. Throughout the year, NGOs monitor the work of the ICC and states parties and advocate through the coalition's advocacy teams. At ASP 12, NGOs held many side events and contributed to the plenary discussions on victims, cooperation, as well as to the African Union debate, requested debate on the indictment of sitting heads of state and its consequences on peace, stability and reconciliation. The Assembly was mostly dominated by discussions that led to changes in the ICC's rules and procedure of evidence, and civil society was vocal throughout, underlining the need to protect the Rome Statute core provisions of equality and no immunity, as well as to keep victims at the center of all considerations. So I'll now turn the floor over to President Intelmann, who will give you a more in-depth look at the Assembly's outcomes and the way forward.
Thank you very much and good evening. It is a real pleasure for me to address you today and thank you very much for the interest in the ASP. As a way of introduction, I should really say that ideally in the future, hopefully in 2 or 3 years already, the ASP will become the most boring place on earth, and ideally it would last for only a couple of days and just pass some technical decisions, including the budget of the court. Unfortunately, we are not there yet. And this ASP that ended on 28th of November has probably been the most political one, or at least addressing the most politically sensitive issues ever. I must say that we really made a big effort also to bring as many states parties to the ASP as we could. Sometimes we are facing challenges, especially when the meeting is held in The Hague. Not all delegations are represented here, but given the nature of this meeting and also the focus of this meeting, I really thought it was very important for as many African states parties and other states parties who sometimes do not find their way to The Hague to be here and to participate. We also made an extra effort to reach out to people through Facebook and Twitter and other means of communication. When I sometimes talk to diplomats, they say, yeah, we know that you are tweeting, you have a Twitter account, and I always say, but it's not for you. It's for those people who do not have access to any other information, because there are people who feel affected by the work of the court, but who do not have access to first-hand information. Now, from what you could read, of course, and sense, it was mainly all about the African Union, the relationship between African countries, African Union, and the court, and also about Kenya. But I would like to walk you through some of the, let's say, regular issues, because the Assembly does have a certain role, a certain mandate, and we did go through these issues also, and with a considerable success, I should say. First of all, we gave the court a new judge, Mr. Jeffrey Henderson from Trinidad and Tobago, and the swearing-in ceremony was held today, and he will start to work from early next year for the court. This election was interesting because for the first time ever, the Assembly members were assisted by the Advisory Committee on Nominations that we had set up last year. As everything in the Assembly of 122 members, things become difficult. So we had to make difficult choices among the very eminent professionals, experts who had wished to participate in this exercise. But now we have a group of independent experts who advise states about the qualifications of judicial candidates. They conduct thorough interviews, and I'm really glad that states do read these recommendations and these overviews that are being presented to them. Next year, as you may know, we will have a bigger election, a regular election, with 1/3 of all judges being elected, and there I really hope that states parties once more will look into the conclusions that the Advisory Committee on Nominations makes. As every year, we have adopted the budget of the court, and for the next year it stands at 121.6 million euros, which is again a considerable increase from last year. And I'm very pleased to say that we did adopt this budget in an extremely civilized manner, which was not the case, for instance, 2 years ago, when we really had to do some very rough negotiating and maybe did not take into account really the best interest of the court. But we were in the middle of economic crisis, financial crisis, and those were the circumstances. For the next years also, the registrar has informed us that he will try to restructure the registry so that it generates savings, and those savings then could be used by the Office of the Prosecutor that really needs additional resources to carry out her work in a manner that is really appropriate, considering the increasing number of situations that they have to deal with. Another today rather boring issue is the independent oversight mechanism. I understand 3 years ago that constituted the main drama of the Assembly meeting, and with one part of the court saying that the states were trying to establish too much of interference or supervision into the work of the court. This year, after 5 years of discussions, finally the Assembly established this independent oversight mechanism that is indeed already foreseen in the Rome Statute. Last year, we had 2 topics, substantive topics for specific discussion, and it was considered to be a good thing. So this year we did almost the same thing. This year's first topic was victims. The focus was on participation, reparations and communication, and this was the first time after Kampala that the Assembly took up this topic. And the second one was a traditional topic, cooperation. It is, I think, also in this particular period where we are right now, important to look into substantive matters. Why are we doing what we're doing? We have to remember that there are victims, there are affected communities, and we shouldn't forget that. Somebody in the negotiations that we had, that I will touch upon later, when the negotiations were over, came to me and said, but did you notice that nobody ever mentioned the victims? Because it is so easy to forget them. They are not out there shouting or going to the Security Council or anything. They are very quiet. And it's easy to forget them. I had a personal pleasure and honor and privilege to visit some of the projects that the Trust Fund for Victims is carried out in northern Uganda and in DRC a couple of months ago, and I could really appreciate what can be done with the money that states give to the Trust Fund. And it's also very good that during this Assembly meeting, states made additional pledges of almost 6 million euros. And really the activities of the Trust Fund, even one of the members of the board told me that at first when I heard about a psychosocial rehabilitation, I thought, what is this? Does it really make sense in these situations where still conflict is going on and you really don't know what is happening? There are so many economic challenges. But when you visit these people, then you understand that people are the same everywhere, more or less. The big picture is the same. People's hearts are the same, their souls are the same, although they live in much poorer conditions. And one woman told us that she was a victim of torture and rape, and she said that she was so ashamed of herself, what had happened to her, that she was not able to come out of her hut anymore. That she just did not have the courage even to appear in front of other people. But when you end up in such kind of a psychological mindset that you are not able to show yourself anymore to other people, you naturally die of hunger and you're not able to take care of your children. So these are also issues that you see, and you gradually start appreciating what the Trust Fund is doing. They're also doing a project targeting children who were not at school, they were child soldiers, or they were born to mothers who were in the forest serving these child soldiers. And there's a very peculiar thing that when these children are sent to school, they have completely lost the understanding, or actually they have never had the understanding, that when you do not agree with another kid, that you do not have to kill him, or you do not have to beat the kid up, that it's actually possible to have a verbal interaction with the other kid and sort things out. And these are the things that have to be taught also. And there are many, many kids like that. So I was very privileged to see all of that, what is happening, and I really hope that also private donors will give more money to the Trust Fund for Victims. Also, the visibility of the ICC sometimes is a very difficult thing, because sometimes in affected communities people do not understand the value of really delivering justice somewhere very far in The Hague, but they do understand the value of somebody coming and helping them with a job or something like that. So that was, one discussion was the victims. The other one was cooperation. And cooperation is also a very interesting topic, in a way that everything becomes very sensitive all of a sudden when you talk about cooperation. Last year, the focus was, throughout the last year, the focus was on one specific issue, the agreements that states are encouraged to conclude on the protection of witnesses. And Norway was leading this discussion, and there were two seminars held. One was held in Dakar and one was held in Arusha, and I'm very glad that also the Estonian government, my own government, was able to contribute financially to these seminars, because going to people and gathering decision makers regionally also then has mobilized these decision makers to conclude witness protection agreements with the court, and these witness protection agreements are badly needed. But another thing that I want to say in connection with cooperation is non-cooperation. And there we have to be brutally honest. The non-cooperation report that the Bureau now produced for the second time, nobody knows what to do with this report. So it is just left there and nobody wants to touch it. I do not have a magic solution to instances of non-cooperation, but of course if the Assembly keeps ignoring this question, it also shows that we are not very strong in our resolve. So what we do in instances of non-cooperation, we work very closely with the civil society. I, of course, send messages and letters to those states that are about to produce an instance of cooperation, and of course the court also issues then notifications and then afterwards findings of non-cooperation. But we really have not been very efficient in this work, and we have not been bold enough to actually also come together at the Assembly and have a discussion about that. I hope that it will happen in the future. The complementarity and domestic capacity building is one of the issues that states were encouraged to speak about it during the general debate, and not so many did, which also shows you that really the one major building block of the Rome Statute system, domestic capacity, and the necessity to build up domestic capacity, is not getting that much traction. We have to work on that more, but really it is a continuing problem. Now let's go to the African issues and Kenya issue. Here I have to say that, of course, the frictions with African states parties or African Union, it's not something that is completely new. But over the past summer, we saw a situation whereby the tensions became so big that the African Union sent a delegation to the court to have political talks with the president of the court. And by definition, these political talks were bound to fail, because the president of the court, being a judge, had to say that I am bound by the rules and regulations that the states have issued. And we saw that this happened several times. And then after that, the African states parties and African Union decided that they would meet at foreign ministers level in New York, and thereafter convene a summit to discuss again their relationship with the ICC. And this is where the Assembly stepped in. I wrote to the leadership of the African Union saying that you are claiming that there is no place to have political discussions, but there is one place to have political discussions among states parties, and this is the Assembly meeting where all Assembly members convene. And this is how all of this process was started, and actually the African Union did take this message up, and they did request their own members to ask for inclusion of a specific topic, the consequences of the indictment of a sitting head of state on peace and security. So we did have this discussion, and it lasted for more than 5 hours. So it really shows you that there was a need for it. But the results of those discussions were really such that states did come together on the idea that really no one should be above the law, but that there should be probably some flexibilities to allow, for instance, the head of state also to carry out his or her functions unhindered while that same person is appearing in front of the court. But also it was very clearly said that the Rome Statute amendments were not absolutely necessary for that purpose. And I think that also the tonality of this discussion was quite good. A number of African states parties took the floor also, maybe not from the very start, but then they warmed up. And at the end of this discussion, there was this kind of a satisfaction also. Because I think it's the worst thing is when more than 50 states assemble in Addis Ababa and have a picture of the ICC that completely does not correspond to reality. So at least we were able to bring some clarifications, and we also brought in people who had been with a negotiating history of the Rome Statute, and the discussion was chaired by the first president of the Assembly, Prince Said Al Hussein, so that they could enlighten the participants how we ended up with the statute and why we created this court, what was the intention in 1998. And stemming then from those discussions, we started also addressing the flexibilities, so to say, so what to do. And as you know, we had decided that at the end of first judicial cycle, we would look into the rules of procedure and evidence. Within the Rome Statute, these rules of procedure can be only changed by states parties, whereas in ICTR, ICTY, they can be changed by the tribunal itself. Here, we have reserved this right to ourselves. So we have been painstakingly working on that according to the so-called roadmap, and we had agreed to amend Rule 68 and Rule 100. 100 says, makes it easier for the court to decide to go in situ, either for parts of trial or for the whole trial. And I really, frankly speaking, I think that this should be the future of this court in some years, to go in situ, to go closer to the people who actually feel the need for justice. Of course, it requires logistical arrangements, and sometimes also political realities are forbidding. But I really think that the court should be very open to this, because otherwise states may feel that it is losing its relevance. Now, Rule 68 allows the use of prior recorded testimony in trial, which is also supposed to facilitate and expedite judicial proceedings. And then the Assembly also, at quite a late hour, at the beginning of November or end of October, had started thinking about new rules. And these rules speak about the participation in trial of the accused via video link or by counsel, represented by counsel, either for parts of trial or for the whole trial. Of course, it would be then decided on case basis by the judges. And if you look at RUTO proceedings, you could already see that the judges themselves were looking for these flexibilities and trying to interpret the statute so as to give also the president and vice president of Kenya some possibilities to carry out their duties to which they had been elected. So, in essence, the Assembly came to assist the judges, and that was appreciated by Kenya, and hopefully this feeling of appreciation will last. Now that we enter in 2014. So this is what we did, and I really think that this political dialogue, of course, should not become a total must in the Assembly meetings, but at least we have identified that political dialogue, even very open dialogue is possible. Before, even last year, I had really met many delegations who were saying there's nothing to discuss. It's a judicial issue. We have established the court. These are judicial issues. There's nothing to discuss. And I can also understand that point of view. Really, there is nothing to discuss once you have established a court and set up its rules. But as we saw, sometimes political tensions become so acute that you have to come together and see what you do. I really feel that there is a very, very strong place for the ICC. I hope that we will achieve universality of this court, but of course, right now we have to work together, and we have to consolidate states parties in the common understanding as to how this court should work and as to how we should cooperate with the court. For the next year, this will be my last year as President of the Assembly. For the next year, I hope that we will, as members of the Assembly, turn back or revert to business as usual. That we will calm down, that the tensions will get a little bit lower, and that we will focus again on cooperation, that we will turn into action all these decisions that we have taken, and of course keep working on universality. What we have been also trying to do over the past year and even before is to look into the setup of the Assembly itself and to have a critical thought about whether we're doing the right thing. And I'm not sure we are. The Assembly, with its working groups, has grown immensely over the past years. You know that there are two working groups. One is in New York and one is in The Hague. So running it in two places creates some kind of cacophony sometimes, and there should be always these people who run between the two places and try to bring the two parts together, and this has been a challenge. And also the proliferation of different discussion groups has sometimes led us to the situation where all these discussions last for a very long time, and the focus on deliverables seems to be disappearing. So we have tried to restructure the Assembly as much as we could to streamline a little bit of these discussion groups. And let's see how it all goes next year. And of course, I will be still very much privileged to be the President of the Assembly for the next months. And I very acutely remember what Prince Said, the first President of the Assembly, told me when I took office. He said, "You have to remember that when you are President of the Assembly, every day you damn yourself and you count the days when will all this torture be over. But once it is over, you will see that it has grown to your heart." So I hope that this is how it is, and I hope that the ICC will become stronger. Thank you very much.
So thank you very much.
That's it now.
If you like, yep, you can take questions from there. So thank you for the very interesting presentation. Take some questions from the floor. I see one hand.
Thank you. Well, I'll stay seated, seeing as I have a microphone. My name is Stephanie Barber from Amnesty International. Thank you very much, Madam President, for your reflections. It's most interesting to hear them. You have this unique herding cats role within the ICC system, and it's a pleasure to hear your views. A quick comment, if I may, on Rule 134 and the outcomes of the session, and then two questions for you looking more ahead. I was interested to hear your characterization that the Assembly came to the assistance of the judges in grappling with the thorny issues that are tackled in 134. I think it's important not to lose sight of the fact that the judges themselves, in expressing their views in the form of the Working Group on Lessons Learned, raised very serious questions in advance of the Assembly about whether presence through video link would in fact be legal within the framework of the Rome Statute, and whether in fact creating a special rule for sitting heads of state to be excused from trial would also be within the framework of the Rome Statute. And these are questions that may yet to be tested in the future, but of course now in the hands of the court rather than the Assembly, the rule having been adopted. I was very pleased to hear your reflections on the substantive plenary discussions, which were unfortunately somewhat overshadowed by all of the Africa issues at the Assembly, but they were very important. In the omnibus resolution, the states parties agreed to have future discussions on victims and complementarity and cooperation, but didn't specify when those might happen or what they most might focus on. And I just wonder if heading into ASP 13 next year, you have views and ideas on what they may focus on. No, I'll leave it there. Thank you very much.
Thank you. Do you want to take a couple of questions? Yeah. Also, at the back. Yeah.
Thank you very much, Madam President. My name is Monserrat Carboni. I'm from the International Federation for Human Rights. I thank you very much for your words and for your honesty. I really appreciate your comment that somebody told you that nobody mentioned victims during the discussion of the sitting heads of state, and that was our impression also. And that is quite worrying because we consider victims to be at the center of the court and of the mandate of the court. So here I would like to ask if you have any ideas whether it will be possible to streamline the interests of victims into the discussions of the Assembly of State Parties to make sure that state parties consider it as a real essential element in the Rome Statute system. I have a few comments, if I may. In relation to the budget of the court, you mentioned that there is an expectation that your reorganization of the registry might generate savings. Our concern in relation to that expectation is that a reorganization, if it's really to make the system more strong, it might eventually lead to more expenses in certain areas that have been underfunded in the last few years, in particular victims' participation and all the system to ensure victims' rights. And finally, my last comment is we appreciate really the reflection about whether the actual present setup of the Assembly of State Parties is the best. One of the key issues that we have been advocating for at the Hague Working Group, and also in relation to the subsidiary bodies of the Assembly of State Parties, is transparency. Transparency including in the work of the CBF. At present, all the reports presented to the CBF are considered confidential, even if the court may not consider them confidential. And probably there might not be any reason really for them to be confidential. So this is just an example, but maybe there is a need of more reflection about how to improve transparency in the work of the Assembly. Thank you very much.
There was a question about the new rules. Of course they raise question, and of course we have to be mindful that all of that was done very quickly. Normally the amendments to existing rules, they take for a whole year, going back and forth, from The Hague, discussing with judges, then going to New York so that everybody is totally happy. That was done very quickly. The judges were consulted, but obviously it was done because of political considerations of the situation and against the background of what happened in the Security Council. We know that the Security Council was not able or willing to accommodate Kenya, and really against the background of all these political tensions. So yes, there is a political element there, of course. The judges will now interpret these rules. I have read also some of the criticism. What can I say? I think that I was the only non-lawyer in the room. All states parties were represented by very distinguished lawyers. So I guess that they knew perfectly what they were doing. And we had a discussion today also with judges, and the bottom line really is that there is this feeling that there were probably situations that we were not able to foresee when the Rome Statute was negotiated, and that we should find some flexibilities. I also know that representation by council is something that is used in ICTR, for instance. I was just told recently. So it is not totally unusual. But we will now see how these new rules will be applied, and of course I'm looking forward to it with great interest. How we would address next year the topics, particular topics. In my understanding, the cooperation has already become almost like a standing agenda item. So probably cooperation will be included as separate agenda item. What else would be included and how all of that will go will probably also be a little bit up to the next president, whom we will of course also consult once we will have identified him. Concerning victims, how to bring more victims more to the forefront. Positive thing that I would say, if you look at the pledges to the trust fund, you see that a lot of money has been given. So states are aware of the particular position that victims are particular role that victims play in the Rome Statute system. What else could be done? I don't have a very good solution to it. I know that the trust fund really is doing a lot during every ASP meeting, really to show their work and also to show pictures and so on, and to show their projects and so on. But yeah, we have to be mindful of the fact that some of the victims are even dead. So they are not here to tell their story. And when the man in the dark suit appears in the courtroom, everybody looks at the man. And sometimes he looks nice and he looks innocent. And he is innocent until proven guilty. But everybody sees him because he's there, and you have the video transmittal of the proceedings. And that's life. The savings, the budget of the court. I really trust that the new registrar is doing things that are not harmful for the overall court functioning. But also, really, we have to be mindful of the fact that if you look now, every year, at least one situation has been added to the court, so to say, workload. And states are not able to give that much money, additional money. And it's quite clear that really the entry point for the court is the office of the prosecutor. It's the prosecutor who brings cases to the court. And if the prosecutor does not have enough resources really to prepare very solid cases, then the work of the court may suffer as a whole. So that is now the understanding, and that really the office of the prosecutor needs a little bit more money. But I really trust that the registrar is not going to harm anything. The transparency of the CBF work, I do not know about this. I cannot comment. I will take this information back and look into it.
Okay, thank you for those responses. Do we have more questions here at the front?
Hi, thank you very much for this honest presentation, President. I have a question about the state's cooperation issue. Apart from one presidential statement in 2008, if I'm correct, from the Security Council, there has been no response from the Security Council of any kind in regards to the complaint or notifications from the chambers, from the president, and from the prosecutor about the state's cooperation issue. I wonder if you have any comments on that, and especially keeping in mind that the ASP has the power to do something about the non-cooperation of state parties, and there are a few states in this issue who are state parties to the statute. Does the ASP have any plan to engage in any further actions other than working together with civil societies? Thank you.
Thank you. My name is Yad Ben Masoud. I am a PhD student in the University of Paris. I have a question concerning the situation in Syria. The High Commissioner of Human Rights has qualified some crimes there as core crimes and transferred the situation to the ICC, not through the Security Council. What do you think about this situation? Thanks.
Maybe take one more if there's... Okay, I'll go for those.
Okay. About state cooperation, in general, because we always complain, right? Oh, there are these things, those things still need to be done. But in general, state cooperation is quite good, and this is what the prosecutor always stresses, that most of the cooperation requests go to African countries because the situations are there, and most of them are responded positively. And if you look at now in this Bemba case, 4 people were arrested at the same time, thanks to cooperation also between these countries and the court. And it concerns a key issue, the irregularities with and trying to influence witnesses. So it's a very important thing to show also that the court does not tolerate this kind of behavior. So in general, cooperation is good. What is a problem is, of course, the arrest of the Sudanese president. This is something that is in everybody's mind, and really there not a lot of progress has been made. When we find out that he is about to travel to any of the state's parties, as I said, I do write to the political leadership of that country. The court also orders that country to arrest President al-Bashir, and then sometimes it has been the case, for instance, he went to Nigeria, he had to leave very quickly because the situation became tense there in Nigeria. So we are doing as much as we can. We have basically limited his possibilities to travel freely and in a carefree manner. So we are making his life a little bit difficult. But this is all that we can do for the time being. Fortunately, it is a permanent international criminal court, so there is all the time to wait. Nobody is telling us to close down. I also know that in the Security Council, really, states parties are pushing very hard to find ways of responding to findings of non-cooperation. But there is no magic solution, because there are also non-state parties in the Security Council. But if you look at what the Council really has done, it has even established forces that have in their mandate the capture of ICC fugitives, for instance, in DRC. The Council is gradually moving towards recognizing the needs of the ICC, with one exception, and it's the exception of sitting president of Sudan. The ASP, as I said, can put some language in the documents, and mainly that language encourages the President of the Assembly to do more and do better in these circumstances, which of course I will try to do. But how and what, I will have to figure out. Syria is not a state party, and thereby the court really has no jurisdiction over Syria. And the only two possibilities are if the Security Council reverses the situation, which is absolutely not likely, because there are states that have veto that are not going to allow this to happen. And another possibility is that when Syrian authorities themselves accept the jurisdiction of the court or accede to the statute. This I do not also see happening, and these are the only two ways for the court to get involved in the Syria situation. But I'm still hopeful that impunity will not be allowed, because a lot of people have been killed in Syria. So I hope that, you know, within the peace deal that will be somehow at some point negotiated, there will also be a place for accountability.
Thank you. Any more questions? Okay, I've just a couple of myself actually. Maybe we can wrap up with these. The ASP budgets seem to go through relatively easy this year. Canada at the last minute agreed to the budget increase. I'm just wondering how you see that playing out next year. And also on the request for a special session of the ASP to discuss amendments to the Rome Statute that has been requested. How do you see that one playing out as well?
Well, I'm not very good at seeing into the future very clearly. But concerning the budget, I'm hopeful. I think we all learned our lesson 2 years ago. It was not very nice, and it's not really worth it. The budget of this court is not so big, and it should be handled in a routine manner. It's just not worth it spending the whole year looking at this budget and then still not being able to trust the CBF, so to say, recommendation and viewpoint. The special session, we will see. I do not think that the next year will be extremely easy. There are numerous amendments to the Rome Statute that were already tabled with the UN Secretary General according to the procedure foreseen in the Rome Statute. I am not aware of that country who tabled them wanting to withdraw them, so they will be circulated very soon, and then we will see where we take it from there. The special session can be convened either by decision of the Bureau or then by request of 1/3 of states parties. And you may remember that already last summer there was a request for convening a special session, and at that point the Bureau could not find consensus about the appropriateness of this exercise. I also very strongly believe that states parties should not be rushed into amending the Rome Statute. This is a document that has a very big value. It was negotiated in a very specific time in history, and opening it in a hurried manner is not necessary. And this is the course that I will take over the next year.
Great. Thank you for that. So if there's no final questions, we'll conclude there. Our thanks to you, Madam President, for your excellent presentation, and to you for your questions. This is the last SCL lecture of the year. The next one, I guess, will be in January, February, when the growth year season will take over. So we wish you the best of luck in your final year as president, and yeah, have a good night, everyone.
One small comment. There's actually one more supernatural.
Oh, there you go.
Yeah.
Next week.
Trials and absentia. Yeah.
Okay. So that'll be on the ASTRA website.